very much for coming to the afternoon session. I hope you had a good lunch, and I heard the morning went very, very well, so I'm glad people were pleased with that. This afternoon, I have the distinct pleasure of introducing Lee M. Manasevit from the Washington law firm of Brewstein and Manasevit. Lee's practiced in the field of education law since 1974. That's a little scary. It's the year after I graduated from high school. So. Beginning as a trial attorney in the Civil Rights Division at the United States Department of Justice. During his government service, Mr. Manasevit regularly appeared in federal court representing the United States in civil rights cases involving educational institutions across the nation. His work included one case that was ultimately decided by the U.S. Supreme Court, and he has also defended the U.S. Department of Health, Education, and Welfare in cases where the department was accused of overly vigorous enforcement of school civil rights cases. Mr. Manasevit's government experience has given him an extensive familiarity with the intricacies of navigating the federal bureaucracy and managing school districts. As one of the two founding partners of Brewstein and Manasevit, Mr. Manasevit established a law practice that addresses the legal issues involving educational institutions, public, private, elementary, and secondary, or post-secondary at the federal level. He has appeared extensively before all tribunals of the U.S. Department of Education and regularly pursues federal court review of unfavorable agency decisions. On the elementary and secondary level, Mr. Manasevit has worked extensively on No Child Left Behind. He has advised and trained schools, districts, states, and private providers throughout the nation on the implementation of NCLB. And he has frequently served as a keynote speaker at national and statewide organizations of Title I professionals. He regularly advises recipients of Title I on implementation issues. And Mr. Manasevit co-authored a comprehensive manual on No Child Left Behind and its predecessor, the Improving America's Schools Act, and has provided editorial consultation on several revised editions. He has also written several articles on NCLB. Mr. Manasevit also has a nationally recognized reputation in the area of special education. He has represented schools and school districts across the country in complex special education matters. When the Individuals with Disabilities Education Act was reauthorized in 1977, and again in 2004, he co-authored a detailed how-to manual on the new law and conducted regional workshops and trainings on the provisions of that law. He regularly makes presentations to education groups on the requirements of this law. Mr. Manasevit manages a higher education practice that covers all aspects of compliance with Title VI of the Higher Education Act, Title IV of the Higher Education Act. This practice includes changes of ownership, accreditation, and all adverse actions brought by the U.S. Department of Education. He has represented institutions before all tribunals of the U.S. Department of Education, all major accreditation agencies, as well as in federal court. Of note, and this is important to New Mexico, recently Mr. Manasevit successfully represented the state of New Mexico in the Zuni Public School District 89 v. the Department of Education before the United States Supreme Court. Mr. Manasevit is an honors graduate from the University of Connecticut School of Law. He received his undergraduate degree from Columbia University in New York City. He is a member of the California Bar, the District of Columbia Bar, the Bar of the United States Supreme Court, and several bars of the United States Courts of Appeals. Please let's give Lee a warm welcome for Mr. Lee Manasevit. Thank you. I'll be in another room.
Well, thank you very much. Thank you all for the welcome. It's my pleasure to be here, and I look forward to speaking for the next few hours on the exciting topic of the new Omni Circular. For those of you who are not excited about it, I hope by the end of 3 hours you will be. It's always a question of whether you want to take these topics first thing in the morning when people are just waking up, or if you want to do it at the end of the day when they're sort of that lunch snooziness is hitting them. But we'll see how it goes. What I want to do today is a couple of things. I want to first just give you the background on what the Omni Circular is, where it came from, why it's here. I'm going to talk about in the initial couple of minutes that we have some of the broader concepts that are coming from this circular. Then the structure of it, how it's organized, structure. And then a fair amount of time on major changes in the circular. And if you don't really know what I'm referring to, you will by the time we really get into it. But mostly, the point of this presentation today is to create your relationship with the circular so that you will be able to use it as an effective tool in your responsibilities for managing public federal education funds. So there's going to be a very practical aspect, a hands-on aspect. We're going to go into it. That's why I wanted you to all have the booklets. I'm going to explain to you the format that it's in now, the format that it's going to be in when it becomes final, and exactly how to use it. So with that, let's start, and we're going to go through the slides. So let's start with what is it, and let's go really to the basics. The Office of Management and Budget is a federal agency in DC. It's under the White House. It's an executive agency, and it publishes from time to time rules that are applicable government-wide, agency by agency. And those rules cover all sorts of different areas, but for our purposes, the rules that we're going to focus on are the rules that govern the care, management, receipt, expenditure, and accounting for federal funds. Because all of us, all of you, whether you're at a state or a school district or charter school, receive federal grant funds, and whether they're No Child Left Behind, now known as Elementary and Secondary Education Act, whether they're IDEA or Perkins, whatever they are, you receive them and you're subject to these government-wide requirements. What the situation was before this, what is called Omni Circular, was that there were a number of different circulars, and those different circulars governed expenditure of federal funds depending on the nature of the organization expending them. So if you were a not-for-profit, you had one set of circulars. If you were a school district, you had another set of circulars. But here's where it got pretty complicated. If you were, for example, a school district, you were subject, when you expended funds, to all the circulars that govern state and local governments. But if you were to give, as a school district, a subgrant to a not-for-profit, that not-for-profit would expend the funds subject to its own circular. But here's where the complication came in. You, as a school district giving out a subgrant, were responsible to assure that this not-for-profit that was your subgrantee complied with its circular. So right off the bat here, you're responsible for two circulars. They were similar, but not exactly the same. And there were some areas of significant deviation. Now, it got even more complicated because if you as a school district gave out a subgrant to an institution of higher education, college would have its own circular for what are allowable expenditures. So if you had a subgrant to a not-for-profit and a college, now you're already in three circulars. And there are different circulars for grants management and for allowable expenditures. So you would be responsible, if you were a school district or a state giving out subgrants, you were responsible for all these circulars, and they had nuance differences. And it was It was very complicated, figuring out the differences, being aware of the differences, and enforcing them. So what the Office of Management and Budget decided to do was to take eight different circulars, which run the gamut from the ones that cover colleges, universities, not-for-profits, state and local governments, and put them into one. And that began in late 2012, and I'll go through the cycle of how we got here, and we're really looking right at the end of the cycle. We're not quite there yet, but we're going to be there. So let's look at what we have. We have A102. That was the circular that governed administrative rules for state and local governments. That under these circulars, a school district or an SEA is considered a state or local government. So you were subject to A102. Then there was A110, which were the general administrative rules for institutions of higher education and not-for-profits. And then you had specific circulars that dealt with cost principles. A87 dealt with state and local governments, but then you had A21 for the higher education institutions, A122 for not-for-profits, and then you had two, A133 and A50, that governed audits, set forth various rules for audits, and then you had another circular that cataloged federal grant programs, essentially. It's called the Catalog of Federal Domestic Assistance. What the Office of Management and Budget said is, this is really inefficient. We're going to put all these together, and we're going to make one, what they call an Omni Circular, and we're going to make it consistent throughout. So the move was towards simplicity, especially consistency, and it was part of a general initiative, and also there were a couple of executive orders from the president on regulatory review to increase efficiency, but along with that, strengthen oversight. And we're going to see two predominant overarching themes that came out of this. And one is that oversight, strengthening oversight, but also a theme of trying to elevate performance standards over compliance, so that the emphasis under the new circular and in much of what we're seeing coming out of the U.S. Department of Education is we want to be more performance-based in our evaluation of the grant programs. So is this going to happen? We never know what's going to happen, but that is definitely part and parcel of what the language all about this. Another part of the effort was to avoid overlap and duplicative guidance, because a lot of the areas were overlap. So where did this come from? It came from a national a council, I should say. It's not an existing organization. It was pulled together for Council on Financial Assistance Reform, including key stakeholders. It had business officers, auditors, accountants, lawyers. It had federal officials, prior retired federal officials. It was a broad coalition of people who have dealt with this issue. And they had worked on it sometime before even 2012. 2012 was when the first announcement came, not a proposal, but an announcement that this was going to be underway. This Omni Circular is going to cover every non-federal entity that expends federal funds. So that's a pretty plain and simple category. If you're not a federal agency and you expend one federal dollar, no matter who you are going to be subject to this. So let's see what happened. In late 2012, the Office of Management and Budget made an announcement that there was going to be a process that would result in what they were calling it then was a super circular, but that would combine all various circulars. So in February of 2013, a notice of proposed rulemaking was released, and that was subject to public comment, and there were hundreds and thousands of comments. The comment response from the public was massive, as you might imagine, because of the incredible coverage, the breadth of the coverage that this circular is going to have. The final rule was released December 19th, but that's just sort of a chronological date, because the important date is December 26th, and that's when it was published in the Federal Register, and that's what you have. And I'm going to talk about the document in the Federal Register, which is currently the official version, but it's not going to be the place where we're going to see it the most in the future. So then the next step is going to be the compliance supplement, and I'm going to come back to that in a minute, because the compliance supplement is a part of this process, and it's a really critical part of the process, although it's sort of collateral to the actual Omni Circular, and I'm going to explain that at the end of this slide. So what happens with this final rule? The final rule is the rule from the Office of Management and Budget. Each agency has to enact its own regulations that adopt this rule. And those regulations will mostly, at least history tells us, most of those regulations will mirror exactly what the Omni Circular says. The Omni Circular itself says that you really can't deviate from this unless you come to Office of Management and Budget and you get special permission. So there's a push here to keep the federal agencies within the scope of where OMB came. And that, again, is completely consistent with the whole purpose here, which is to have consistency agency to agency. So if you get a grant from the Department of Agriculture, and you get a grant from the Department of Labor, and you get a grant from the Department of Education, the regulatory structure of the requirements for that grant will be, if not identical, they'll be very similar and consistent. So that's the idea. The agencies have to come out with regulations by June 26, 2014, which is exactly 6 months. They were given 6 months, but those regulations then will go to OMB, and OMB will either approve or disapprove or whatever it's going to do, and then the agencies will publish their final regulations in December of 2026 of 2014. Now, one of the things you'll notice about that date, December 26 of any year, it's right smack in the middle of a fiscal year. And you can't really have two sets of administrative regulations governing a grant, one for the first half of the year, one for the second half of the year. So they will phase in based on grants that are the next time that a grant is made after that date. And so they'll begin with the next full fiscal year. So that's where we are in the time frame. What I want to do is go back for a minute and talk about the compliance supplement. The compliance supplement is published by the Office of Management and Budget in conjunction with it's in conjunction with A133, which is the Audit Circular. And A133 now, currently, until we move to the Omni Circular, has the basic audit requirements for auditors when they do your single audit. And the A133 itself is much more audit procedural, how the auditor has to proceed, what the auditor has to look at in terms of, do we only look at big programs, do we look at small programs, how do we pick programs, and things like that. But the A133 has attached to it what's called a compliance supplement. The compliance supplement will now be attached to the Omni Circular. And that's not going to change much. But what is so important about the compliance supplement is that where it comes from. The Office of Management and Budget puts out the compliance supplement as an attachment to the audit process as a means of educating the auditors who are doing the single audit your annual audit, as a means of educating them as to the substance of the programs that they're looking at. What's the requirement for an eligible Title I student? What are the areas that I can spend IDEA special ed funds on? Can I pay a paraprofessional? Things like that. Those are answered in the compliance supplement. It's not set up as a Q&A. It's set up really as an outline of the programmatic requirements. Now, OMB publishes it officially and is responsible, but where does it come from? OMB has the agencies that administer the program draft the compliance supplement for those agencies. And there's a compliance supplement for every agency. And this is a much underutilized document for people that are involved at all in compliance or grants management, because it is an ideal sort of X-ray vision into all the priorities that the agency feels are the important things for the auditors to look at. And it also gives the auditor the perspective of the agency, what the agency wants the auditor to look at. So it's a very, very important document, and it's really underused. There are many times when we've researched questions that we've gone to guidance and we've gone to letters from the department, and of course we start with the laws and the regulations, but there's a lot of times that you just get to a question that you can't find any authority on, and you may have had a bad experience with the Department of Education telling you something and then telling you something else. So the compliance supplement is an official document that gives a lot of insight into a lot of these programmatic questions. So I always emphasize it, and I always, whenever I'm talking about these overall authorities, I always emphasize to people that this is one of the places that is a very helpful document. So if you're in the position that you ever need to do this, it's very easy to find. You go to whitehouse.gov, there's a link for omb.gov. On omb.gov, there's a link that just says circulars. And then the circulars are all listed in numerical order. They all start with A. So you can ignore the A, and then you just go down a list. And right now, if you wanted to see the A133, if you wanted to see the compliance supplement, you'd go to A133 until at least the spring. And then when it comes out, they may attach it to the Omni Circular. And after the A133, there's the compliance supplement, and then there's an alphabetical list of agencies, and it's under education. And there's every major program of education has an entry in the compliance supplement. So I really always recommend this as a very valuable asset. If the only time that there will be a situation where you will not follow the Omni Circular is only if your program statute or your regulation differs from the circular. Then the statute or the regulation will govern. So, you know, if the circular, for example, says in general you can't spend money on public relations, but if your program says that you're authorized to spend money on public relations, then you would be able to, and you would deviate from the circular. But in general, the circular is going to be controlling unless it conflicts with one of these particular statute or regulations from the program. So the question is, again, nothing will be in effect before December 26, 2014. That's that 1 year date, the 1 year, and then the 6 months, and then the 1 year. And then the question is, how will it begin to kick in? Well, the circular actually says that it will be for new awards after that date. Of course, those will be July, and they'll be beginning a new fiscal year. But it also says that any additions to awards after that date. And that right now is unclear if they just mean additional drawdowns or if they mean increases in the awards. So there's still a lot here that is not completely clarified and that we are going to need clarification on. So here's where we really start to get into the conceptual part of it. And there are going to be additional areas where I'm going to talk about this. But the whole introductory part, the comments, there's response to comments, and I'm going to show you where they all are, just emphasizes and re-emphasizes that this is now going to be about performance rather than compliance. Not that compliance is going to be less important, but that we're really going to look first, meaning the federal agency, the federal auditor, the federal oversight people, are really going to look first to see whether there is performance success. And there's all sorts of requirements that grant programs have performance metrics and that there be performance expectations that are clearly expressed by the awarding agency and things like that. So the idea here is that for the auditors, the reference is A133, but the reference is your single audit, which will still be A133 till next year, and then it'll be the Omni Circular, but it'll be the same single audit that you know of, that the auditors come in every year, and the Federal Office of Inspector General and program monitors, the emphasis is to look for outcomes rather than process. Now, they can't look to outcomes unless the outcomes are there, the outcome expectations are there for them to be able to measure against. So that sort of reflects back that the process of making the awards is going to become much more outcome oriented. So it's rather than an award that says you're going to serve 12 students, the outcome is the award will be at least 12 students are going to make this much gain in progress or measurement. So there will be measurable outcomes that they will look to measure. Along with that is an additional flexibility on internal processes for grantees. So the idea is more flexibility, but more responsibility on outcomes. Also, part of this performance is the idea that there should be innovative program design, so that with the flexibility, there should be greater innovative program design, looking to cost effectiveness, looking to collaboration, to the different potential partners that can contribute to this, and that the federal agency will look to finally provide clear performance goals. The emphasis now on accountability. Now, it seems like maybe accountability and compliance are sort of this overlapping, but they're really not. When they talk about less emphasis on compliance, they're talking about less emphasis on simply Show us exactly what that dollar was spent on. How was that dollar accounted for? Show us the contract. Prove to us that the contract was only used for this cohort of students that it was paid for. Show us your procurement process. Less emphasis on that, but much greater emphasis on accountability. And in fact, the whole section on internal controls in the OMB circulars, that whole section on internal controls used to be just in A133. So it was put there as a audit element that auditors were supposed to look for, rather than having it in one of the circulars that says, if you receive federal funds, you must have this level of internal control. But that part has significantly changed, and the whole internal control section, which I'm going to talk about, is moved into the more substantive parts of the oversight responsibilities. Now, here is one of the things, I'm not going to do a lot of reading for you, but this is something that it's a new provision that goes into that is a requirement for all grant recipients. And I'm going to read this to you because I want you to think about how you would feel if you were the one who was asked to sign this. By signing this report, I certify, to the best of my knowledge and belief, that the report is true, complete, accurate, and the expenditures, disbursements, and cash receipts are for the purposes and objectives set forth in the terms and conditions of the federal award. I'm aware that any false, fictitious, or fraudulent information or the omission of any material fact may subject me to criminal, civil, or administrative penalties for fraud, false statements, false claims, or otherwise. So when I say accountability is ratcheted up, this is part of that. This is a required certification of virtually every report that is going to go to the federal agency, and also the requirement says that it has to accompany any voucher. And the voucher word is not defined, but we believe that it would accompany any request to draw down funds. So this is pretty stringent, and this was put in here, actually. It wasn't in the earlier versions of this. This was put in at the behest of, there's a National Council of Inspectors General, and they said that we need to have this for augmenting the accountability. So let's talk again on some of the, just in the general themes, again, for accountability. That the non-federal entity, that's everybody except the federal agencies, has to disclose in writing, and this is all new, to the federal agency all violations of federal criminal law involving fraud, bribery, or gratuity violations. So we've got fraud and bribery, which are obviously very serious criminal matters. Gratuity violations is a much looser kind of a term, and really a gratuity violation could encompass a situation where your organization, say, has a rule that you can accept from a vendor, say, a lunch that's worth under $25, but the vendor is buying you lunch for $50, or anything of that nature. The rule says you can accept a gift of nominal value no more than $10, and the gift is $15. Those would all be technical gratuity violations. And so it's a very, very broad term. It's a very comprehensive term. And it's a mandatory disclosure to the federal agency. And it specifically says that failure to comply with this requirement can lead to all the consequences of noncompliance, up to and including suspension of the grant or termination of the grant or debarment of the agency involved. Debarment means you're ineligible to receive federal grants. Now, that's not necessarily going to happen on a minor violation, on a first offense, but I just want to give you an idea of the sort of the range of the seriousness that could result here. So what I want to do now is I want to move into the booklet itself. You all should have a copy of this. It's in the Federal Register. And I want to just sort of walk through what's in here so you're familiar with it. Now, all federal regulations, or Office of Management and Budget regulations, rules, federal agency rules, the Federal Register comes out every day, and everything that is going to become a regulation must be published in the Federal Register. It's published first as a proposal, then you get comments, and then when it's final, it's published in the final version. So that's why this is the December 26 version. Now, eventually, the Office of Management and Budget will have these circulars on the website in a more traditional framework, like an 8x10, page by page, and eventually we'll see it in the regulations of the agency, which are all in the education regulations, are in the CFR, the 34 Code of Federal Regulations, if you're familiar with that booklet. But for now, this is the official version, and it will remain so for some time. Now, the first few pages are the sort of the comments, the agency's response to comments, some of the overarching concerns and considerations, and just sort of the general approach. So if you're interested in sort of that overall approach, those first few pages can be very informative. They also discuss some major changes, so they're also very helpful in that manner. But what I want you to do first, well, look at those. And the page numbers are at the upper right and left-hand side of the pages. So turn to 78608. And that is the beginning of the actual Omni Circular. And I just want to walk through the index, and then I want to go through some of the definitions, because some of the definitions, there's a lot of material of substance in the definitions. So I want to go through some of those definitions. But I want to just take a look and sort of show you what is here. So beginning, if you look at page 78608, you've got on the right-hand side of the page the Part 200 Uniform Administrative Requirements, Cost Principles, and Audit Requirements for Federal Awards. That is the official name of the Omni Circular. And you can see you've got a lot of acronyms and definitions for Subpart A. And those definitions I'm going to go through. That's the next step, what we're going to do. Then Subpart B is general provisions. So those are now in Circular A102, and also they're reflected in the Federal Department of Education regulations at Part 80. If you're familiar, if you use the regulations, they're in Part 80. After the Department of Education adopts this Omni Circular, you won't have a Part 80 anymore because it'll be combined, because then we get to Subpart C, which is also A102. Subpart D is also A102. These are the general grants requirements that apply to all grants. And then we get to Subpart E is cost principles. And for state and local governments, those are now currently A87. And they are not in the department regulations. But these cost principles in Subpart E now will be cost principles that encompass state and local government cost principles, institutions of higher education, and not-for-profits. So if you as a school district give out a sub-grant to a not-for-profit and another one to an institution of higher education, you will only have to be making you'll follow these cost principles for your own expenditures, and also you'll be responsible to make sure that they follow the same set of cost principles. So then on the next page, we've got subpart F, which are the audit requirements. So the A133 single audit requirements get folded in here. So that's the overall structure of the cost principles. What I want to do now is just go through some of the definitions. I'm not going to read them, but I want you to be familiar with where they are. So if you go to the next page, 78611, you've got 200.18 and 200.19. Cognitive agency, and what I want to point out here is that you will have a cognitive agency for audit. That's the federal agency that is ultimately responsible for resolving all the single audits, whether you're a state or a local government. That currently, for most of you, will be the U.S. Department of Education. It's generally the agency that gives the most money to sub-grantee. But now there's going to be a separate agency for indirect costs. So there'll be a cognitive agency for audit and a separate one for indirect cost. And the cognitive agency for indirect costs may very well be a different agency. And they'll be the one responsible for issuing indirect cost rates to the state and making sure that the state is following indirect cost process for its local district. Now on the next page, 78612, this is one of my favorite ones. If you go to the first one, 200.20. The reason I really like this is because it's a new definition, and it's a definition essentially of computers. And the thing is that everybody knows what a computer is, and then when you try to define it and you read the definition, it's very confusing. It seems to take something that's very clear and sort of makes it, computing devices means machines used to acquire, store, analyze, process, publish data, and other information electronically, including accessories, peripherals for printing, transmitting, and receiving or storing electronic information. It seems to me that everyone here could have always shown something, you could have said that's a computer or not a computer. But now we have this definition to deal with. But it is, there is a fair amount of attention focused in this new circular to computers, which makes sense because the old circulars are several years sort of behind the times in the electronic world. The next one, 200.22, definition of a contract. What I want to call your attention to is the middle of the definition. The term as used in this part does not include a legal instrument, even if the non-federal entity considers it a contract, when the substance of the transaction meets the definition of a federal award. So I've seen a lot of times that districts, and even sometimes states, will consider what meets the substance of an award, meaning a grant, but they'll call it a contract. And what this says is that you've got to analyze the substance of it, and there are standards that are in the circular for what a contract is and what a subgrant is. And there are a whole different set of rules that apply whether it's a grant or a contract. So it's important that you recognize that when you're going to engage with a third party, if you're a school district, you're going to engage with a third party, even if you've always called those transactions contracts, if they meet the definition of a subgrant, then you've got to treat them as a subgrant. The next one is 200.25, which is in the middle of the page. And for those of you who who receive grants from an agency other than the Department of Education, this is a major step forward for audit resolution. And I want to give you just a little of the background on this. This is an initiative, Cooperative Audit Resolution, that started about 20 years ago now, about 15, 18 years ago, when the Department of Education audit process was extraordinarily onerous, and there was a huge amount of bad blood between the field at the state and local level and the federal agency. And cooperative audit resolution was something that we, our firm, the Inspector General's office, the Office of General Counsel in the Department of Education, and about 6 pilot states worked on to develop an audit resolution process that was auditee or user friendly, that looked at the consequences and concerns about misspent funds that never went away, but the process whose focus would not be only on recovery of funds, that the primary focus would be program improvement, strengthening, and also assurance that the problem that arose didn't arise again. That process developed in the U.S. Department of Education. It actually became part of the U.S. Department of Education's audit resolution process. However, no other agency, and agriculture, of course, gives probably most of you, if not all of you, get grants, your school lunch, school breakfast programs, get agriculture grants. Department of Labor has job training programs. Some of you may participate in those. Those other agencies absolutely refused to engage in anything other than the strict, sort of very adversarial audit process resolution. So this is a major breakthrough because by putting it in the Omni Circular, it is a mandate on every federal agency. And if you look at this, if you look at it with me in 200.25, if you go down towards the end of it to the small letter D, federal agencies offering appropriate relief for past non-compliance when audits show prompt corrective action. So it's the whole thing reads that the cooperative audit resolution includes offering appropriate relief for past non-compliance when the audits show prompt corrective action has occurred. So this is taking the whole COROI process and specifically mandating, I mean, this is a mandate that where you can show, even though you've got a non-compliance, that you took prompt corrective action, that the federal agencies should consider forgiving, essentially forgiving the recovery of funds. So this is extremely important, and we need to walk it back to the audit shows prompt corrective action. So that means that does not refer to corrective action after the audit finds the problem. That means corrective action that was taken before the audit, or at least was in the course of the audit, that was structured so that it can be reflected in the audit, because that's what we want. We want the corrective action to be reflected in the audit, and then there's a huge opportunity here to move away from the sort of punitive, you misspent $1 million, you owe us $1 million. So it's a very positive, a very positive development. The next one, 226, is just a definition of corrective action. So I just flagged it because it relates right to the one before it. Cost objective. Interesting part of this definition. The old definition of a cost objective was a program or an activity for which you were required to collect cost data. So for example, if you had a mandatory minimum in a grant, you had to spend in this grant, you absolutely had to spend 20% of the grant on a non-traditional population, that, by definition, was a cost objective. Why? Because you had to collect data, because you had to show you spent 20% of your grant. No Child Left Behind, an LEA has to spend 1% of its grant on parental involvement. You've got to collect cost data because you must be able to satisfy that 1%. And there are many, many examples either of a minimum that you have to expend or a maximum over which you cannot go over. The interesting thing about this is that it keeps the same definition, but it changes the requirement that the cost objective is where you have to collect data or you need data to where cost data are desired. That language is in the middle. So I don't know if that's bad draftsmanship or what, but you can't comply with a cost objective unless you do collect the data, because you generally have to show that. So let's go on. Those were the main definitions that I thought were of significance, but remember there are a lot of definitions here, so if you get to a point where you got a term that you're not sure, remember just to check the definitions. So let's go next. Where are we? See. Okay, seem to have skipped beyond. The cost principles are set up with, first there are general categories, general concerns, and then there are specific items of allowable costs. And so I want to just spend a couple minutes on the general items, and then we're going to go to the specific items of allowable cost. And there are some changes here. These basic requirements are not significantly changed. There's a couple of minor changes. A cost must be net of applicable credits, meaning if you buy something with a federal grant, and you get a credit from the merchant, that has to be reflected back to the federal grant, either by reducing the purchase price that you're charging or crediting the funding back. And that net of applicable credits was just shifted into a different position. The first one, necessary, reasonable, and allocable, those are really the prime core of determining allowable costs, unless we're dealing with a specific statute that specifically authorizes a cost, necessary, reasonable, and allocable. So for example, we have a lot of programs at the school district level that specifically allow you to spend money for administration, but doesn't say how much. No Child Left Behind, for example, says the state can spend up to 1% for state administration. The district is allowed to spend money on administration, doesn't say how much. The necessary and reasonable is what is going to control that. In the old version, necessary and reasonable were split out. Reasonable always continues to, and always did, refer to price. That what is the reasonable amount of money that someone would pay for this, but it always had to function in conjunction with necessary, because necessary was the relationship to achieving the grant ends. So the example that I frequently use is that if you are going to buy a computer for Title I students for a Title I purpose, and you're going to use it to strengthen reading skills, because that's what your school survey shows is the weakest part of your program, and you buy that computer and it's got programming on it and it's all for reading skills, and it's only going to be used for Title I students or in a school-wide appropriately, but it's going to be within Title I, you've got necessary. But if that's an off-the-shelf computer and it's $10,000, you're outside of reasonableness, because it's not reasonableness. Off-the-shelf computers are under $1,000 or maybe a little bit more if they're specialized for school. So it can be necessary and not reasonable. The alternative is the same as well. It can be reasonable, it can be $850, but it can be for a Title I purpose that really is not an important part or a central part of your Title I program, and it really doesn't add much to your Title I program. So they really go hand in hand. What the circular did, which is sort of interesting, is it made necessary sort of a subset of reasonable as opposed to a separate element. But always, always be prepared to determine the allowability of a purchase based on both necessary and reasonable as separate components. Allowable, of course, has always been with us. Allowable means if we satisfy necessary and reasonable for those computers, and we're going to spend 100% of the cost on the computers, those computers are primarily there for the Title I program. That's the allocability issue. Now, there's a new provision, prior written approval, which is very interesting because it's an optional prior written approval. And that is that if the non-federal entity is concerned, in other words, the state or your school district is concerned that an expenditure might not be allowable, you can write to the agency, the cognitive agency for your indirect cost rate, or the federal awarding agency, and in most cases you're going to want to write to the federal awarding agency because they're the ones who are going to be most familiar with your grant program, and your questions are mostly going to be on programmatic allowability. And you can write to them and ask them if it's allowable and say we want our prior written approval to make this purchase. Now we have, with the Department of Education, already in the Department of Education's basic law, an opportunity to do that. It's called a 90-day letter, but it's a little bit cumbersome. And it requires a letter that goes to the, if it comes from a district, it has to go through a state. It has to have a certification by the state legal officer that he or she believes that this expenditure is allowable under state and federal law. And then it has to go to the federal government, and then they get 90 days to answer the question, and it's sort of a cumbersome process. This will do two things. It'll make the process much smoother, but it'll also apply to every federal agency and broaden that. So that would definitely be an advantage. There's an interesting new rule here on administrative costs. Now, administrative costs, typically, where you have an administrative official, and those are many of your district level people, most of your state level people, that they are generally paid out of direct charges to the program or programs that they work on. And that's typically been the practice. But the new circular says that the presumption should be, or is, that administrative staff and clerical staff will be paid indirect unless you meet a fairly significant or four-part test here. It's really a three-part test. And unless you meet this, they would be paid by indirect. So you have to show that the services are integral to the activity, that the individual can be specifically identified with the activity, and the costs are explicitly included in the budget. These are new requirements for paying someone administratively out of direct. Now I say it's 3, not 4, because costs can never be recovered as indirect and charged as direct. That's a basic rule. That would just be double charging, so there's nothing new to that. But this covers clerical staff. This covers clerical staff as well. Now, clerical staff are typically paid direct based on the people or person that they work for. So if you've got a Title I administrator who works 100% of her time on Title I, or let's say she works 50% on Title I and 50% on migrant, Title I-A, and 50% on migrant, and then the administrator has a secretary. That secretary didn't traditionally have to keep time, but that secretary would be paid the same 50-50 for the person that they supported. This, again, moves that away and goes into this presumption almost that the clerical would be paid indirect. So the next section, I'm going to go to the selected item of cost. We have about 10 minutes, so I'm going to just introduce that section, and then we'll move, we'll take a break, and then we'll finish up. The first category is advertising, and there were 43 items of cost in A87. Not surprising, because now we have 3 different types of organizations covered here. The number of items of selected items of cost have gone way up to about 55, which again is not surprising. But advertising under the old circular, it was a very general. It said advertising is not allowed unless it's part of the grant or part of the grant program. So, for example, when we had in special education in IDEA, when we have a child find and we have to reach out to the public to let people know, is your child having trouble in school? Do you think your child may be disabled? Reaching out to hospitals, medical facilities, types of places where children with disability might be treated or actually just end up, then the child find authorized that reach out, but it was sort of always a question of, are we advertising, or what are we doing? But this clarifies that and says that advertising is allowable when it's consistent with the programmatic purpose for recruiting. Now, where's recruiting going to come? Title II is going to be a lot of recruiting. So under Title II, under this rule, we can do widespread advertising as part of our recruitment activities. Procurement of goods, that was always allowable. Disposable material. Program outreach, that was really my example on Child Find. But there are a lot of other types of programs, safe and drug-free type of programs where program outreach makes sense, because we don't have students or kids who are automatically in it. And we need to have sort of some input from families. Title III would be a good example where we might want some program outreach to families to let them know about support for limited English and things like that. And then there's some very limited public relations that are allowed. Of course, we all love this one. The circular rule did not change. Alcohol is still not permitted as a federal expenditure. And if you're waiting for that to change, I wouldn't wait. I wouldn't wait for that. Obviously, that's not going to change. Audit costs. The cost of the single audit is definitely an allowable cost. It has to be allocated to essentially the programs that are audited. So if your budget is federal budget, of course we're talking about is 60, your federal funds are 50% Title I and 40% IDEA and 10% Title III, then all those programs are going to be audited, and that's how you would allocate the audit cost. You don't need a cost allocation plan, you don't need indirect costs, but you want to allocate it based on the funding that you are expending that is subject to the audit. Other audits are generally not allowable, only if they're included in a cost allocation plan. In general, every state certainly is going to have a single audit, almost all school districts. The audit threshold now is $500,000. It's going to raise to $750,000, but that is what? That is $750,000 of federal funds expended in a year. Not in a program, but in total funds. So that includes agriculture, school lunch. It includes all your federal education programs, any other federal funds that you expend. So still, most school districts are still going to be captured by it. However, there's going to be a gap, and that gap is going to be significant, and that is the smaller mom and pop, maybe even here and there a charter school, or also if you are, as a school district, are giving a sub-grant to a community-based organization, maybe under the $750,000 threshold. And those organizations, the OMB determination was to cut those out because the way OMB looked at it from a national perspective, 99.7% of federal dollars will still be subject to audit by even with raising the threshold to $750,000. That's fine, but what falls beneath the cracks, or it falls into the cracks, are smaller organizations. Obviously, they expend under $750,000, and those organizations tend to be much higher risk because if you look at high risk by risking a lot of money, no, they're not high risk. But if you look at high risk as a lack of internal controls, a lack of prior experience, a lack of all the kinds of protections that we expect for federal funds, they are definitely high risk. I mean, if you look at a public agency, a school district, and you've got a school superintendent, you've got a business officer, and you've got maybe an assistant superintendent for finance, you've got a school board, you've got a controller, you've got all of these various positions that are separate from each other that represent all these controls. You get a small mom and pop organization getting a $500,000 grant for the first time. It may not be a lot of money in the federal perspective, but it's definitely a high risk, especially in an organization that's new. So anyway, that was the logic and the thinking. The Inspector General organization really, really opposed it, but that's where it came down. The proposal raised the threshold even closer to $1 million, which again wouldn't make much change on the public agency level, but would have exempted several more organizations. Conferences that are held and paid for the purpose of training employees for advancing the purposes of the grant are allowable. A couple of significant changes here. Paying for meals is allowable at conferences. However, having said that, we're going to come into an area of, I guess I would call it tension. The U.S. Department of Education has put out some very restrictive guidance on when you pay for a conference, whether you can provide meals. And the guidance really says you really have to determine, even if the conference is fine, whether it's necessary for you to provide the meals or whether people can go off on their own and get meals. And the department's guidance is pretty restrictive. This government-wide guidance is not restrictive at all. But there's much more of a stringent analysis suggested as to whether that you can determine that the conference is appropriate. And also, there's a couple places here where the Omni Circular talks about family-friendly policies. And they're not what you might imagine in terms of, they're not about parental involvement kinds of issues, family-friendly. They're actually about supporting family-friendly policies for participants in the conference. Particularly the references specifically to professional women being held back by lack of family-friendly conferences in the professional context. So the allowable conference cost, you've got the facilities, meals, refreshments, transportation, unless the federal award, of course, restricts conferences. But following down, costs related to identifying locally available dependent care resources. So so the cost of identifying it, in other words, the conference organizer who is being paid out of the federal grant to organize the federally funded conference can spend some of his or her time identifying locally available child care resources, dependent care resources. Not paying for it, but identifying it. But there's another section across reference here that allows a conference cost to include the cost of dependent care that is above and beyond regular dependent care. As long as it's above and beyond only for the time of the conference. So clearly there's going to be a lot of clarification of what that means, but as a practical matter, if someone has a child and a set level of daycare expense or child care expense, whatever it is, and then that person is going to be away for 2 days, and they're going to be an extra couple of $100 of charges, those clearly would be above and beyond regular dependent care. And they're allowable. It's not mandatory, but that is actually allowable. And then, of course, the hosts have to exercise discretion to ensure costs are appropriate, et cetera. Now there are separate sections on travel and conference attendance, et cetera, but this is the section that deals with the allowability of the organization itself holding or paying for the conference. So now I think we're at our break. We have a half-an-hour break. And I'll stay around for the break if you have any questions, and then we'll start again. And I do want to say, normally I take questions during a presentation, but this is just really too big to do that effectively. So I'll be here afterwards, and I'll go to the reception, and we can talk then. So take a half-an-hour break, and I'll see you in a half an hour. Okay, I'm going to start back up. As I know people will be coming in, but I'm going to start back up. And much of the rest of the presentation is going to be on the individual items. The item of cost here, and remember, I'm not going through every one of them. I'm going through the significant ones that have been significant in the past, or the ones that have significant changes. And so this is about legal fees, and that legal fees would be for costs of your in-house counsel, of if you have to pay for attorney general, or outside counsel, lawyers that are hired privately. The prior rule said that